Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Tonight's lecture is going to be on Chapter 13, where we are going to talk about victims and the law. And we'll be covering such things as who is a victim. I'll give you a little bit of history. We'll talk about some legislation as it relates to victims' rights, and then this interesting word called restitution. So we're going to look at a bunch of different things relating to victims and the law. So with that being said, let's go ahead and jump right into our lecture for tonight. So by way of introduction, on June 27th, 1987, Purvis Payne visited his girlfriend's apartment on several occasions, awaiting her return from an out-of-town trip. Now, during his wait, he ingested cocaine, drank beer, and he kind of drove around with friends, and he returned to the apartment later at about 3 p.m. and discovered that she hadn't returned yet. Well, because of that, he entered a neighboring apartment occupied by a female by the name of Charcy Christopher. Her 2-year-old daughter, Lacey, and her 3-year-old son, Nicholas. And he ended up making sexual advances towards Charcy and became violent when she resisted. Now, a neighbor heard Charcy scream, yelling, get out," and assumed that she was directing her commands to the kids. The neighbor then testified that the apartment became silent for a little bit, and then she heard a very loud, blood-curdling scream, if you will, and because of that, she called police. Well, when the police arrived, they encountered Payne leaving the apartment building, and one of the officers testified that he appeared to be sweating blood. And when asked what happened, he claimed to be the complainant who called, which struck the officer, was kind of interesting for the officer. He really didn't believe it. Now, inside the apartment, the police found walls covered in blood and Charcy and her children on the floor. Nicholas, even though stabbed several times with a butcher knife, the wounds penetrating his body from front to back, he was still alive, and his life was saved after several hours of surgery. Now, his mother and sister died. Now, Charcy's body was found on the kitchen floor on her back, her legs fully extended. She had sustained 42 knife wounds and 42 defensive wounds on her arms and hands. And the wounds were caused by 41 separate thrusts of a butcher knife. Now, none of the 84 wounds inflicted by Payne were individually fatal. Rather, the cause of death was most likely bleeding from all of them. Now, Lacey's body was on the kitchen floor beside her mom, and she had suffered stab wounds to her chest, abdomen, back, and head. And the murder weapon there was also a butcher knife, and it was found at her feet. Payne's baseball cap was snapped on her arm near her elbow, and 3 cans of malt liquor bearing Payne's fingerprints were found on a table near her body, and a 4th empty one was on the landing outside the apartment door. So Payne, as you suspect, was eventually arrested and charged with the 2 murders and 1 count of assault with intent to commit murder, and was convicted on charges and sentenced to death on both murder counts and 30 years in prison on the assault. However, at the sentencing phase, Payne presented evidence of childhood abuse, his good character, sure, and the impact his death would have on his girlfriend and her children. Now, family members testified that he didn't have a criminal record, and a psychologist testified that he was mentally handicapped and a well-behaved prisoner. Now, the prosecution presented evidence of the emotional impact of the murders on the son. Charcy's mother, for example, testified that Nicholas cries for his mom, and he doesn't seem to understand why she won't come home or can't come home, and cries for his sister Lacey. He comes to me, she said, many times during the week asking me, "Grandma, do you miss my Lacey?" And while advocating for the death penalty, the prosecutor said, but we do know that Nicholas was alive, and Nicholas was in the same room, and Nicholas was still conscious. His eyes were open. He responded to the paramedics. He was able to follow their directions. He was able to hold his intestines in as he was carried to the ambulance. So he knew what happened to his mother and baby sister. Now, here's my point. The admission of this evidence appeared to be a violation of Supreme Court precedent prohibiting certain types of victim impact evidence. The Supreme Court had previously found victim impact evidence to be violative of the Eighth Amendment's prohibition of cruel and unusual punishment because it was emotionally charged and irrelevant to the elements of or reasons for murder. Now, I know this is a lot to handle, but let me finish. So Payne appealed his conviction through the Tennessee courts to the Supreme Court of the United States. And in a landmark decision, the Supreme Court explicitly reversed itself, holding that victim impact evidence may be considered at sentencing in most cases. And victims' rights advocates applauded this decision. Others, including death penalty abolitionists, kind of basically decried it. And this lecture is going to talk about the situation of victims in today's criminal justice system, and more specifically, victim rights statements, and are these things okay? So there are two victims in most criminal cases. The first is the victim at law. And this is the party that has legal standing to prosecute the person who committed the offense. And in most nations today, the victim at law is the government. And as you learned earlier, the states are the primary victims at law in the United States, although local forms of government and the federal government also possess the authority to prosecute cases within their particular jurisdictions. Now, this wasn't always the case. The common law tradition and the practice in the United States for many years was for victims or other parties affected by crimes to hire private prosecutors. But a shift to public prosecutions began about the time of the American Revolutionary War. Now, today, remnants of private prosecution can be found. In Virginia, for example, the common law right of a victim to hire a prosecutor to act in concert with the public prosecutor continues to be recognized in some cases. So kind of weird, but so the victim in law, the party who has legal standing to prosecute the person who commits the criminal offense, and usually it's the government. Okay? Now, the second form of victim is the victim in fact, and the person who was the subject of the criminal act is that person, the victim in fact. And this lecture is going to kind of examine this form of victim. And the concept of a victim is foreign to civil law, which speaks instead of terms of people who have been injured or wronged. The term victim denotes someone who has been harmed through the kind of activity prescribed by criminal law. So victim in fact, the person who is the subject of the criminal act. Okay, so hopefully that kind of makes sense. Now, although everyone has an intuitive appreciation of what it means to be a victim, the term crime victim can be more formally defined. The Violent Crime Control and Law Enforcement Act of 1994, for example, says that the word victim means the following: any individual against whom an offense has been committed. Now, for certain purposes, however, federal law expands the term to include the following: a parent or legal guardian if the victim is below the age of 18 years or incompetent, and one or more family members or relatives designated by the court if the victim is deceased or incapacitated. So here you have a couple of different things. And the case that I read to you at the very beginning, or summarized for you, I have a link to it right here. This is Payne versus Tennessee. It's a 1991 case, and again, it focuses more on the issues surrounding the U.S. Supreme Court and the Eighth Amendment, which talks about what cruel and unusual punishment is one of the things that the Eighth Amendment addresses, and whether or not it was appropriate for the prosecutor in that particular case to not only allow certain testimony, but the use of a victim witness or a victim statement, if you will. And here you saw the outcome of the case, where in a landmark decision, the Supreme Court basically said that the victim impact evidence may be considered at sentencing. So there's a lot there. Another case that is of great interest would be the Pettit murder case. And I have a couple of videos there that you can watch. And this was basically the kidnapping, robbery for ransom, if you will, murder case that occurred not too long ago. I don't want to divulge the story, but it also talks about how at one point one of the surviving individuals was able to get up and talk about, and many other people do in certain types of cases like murder and rape or things like that, they're able to give up and do a victim impact statement and address the individuals that are in custody or that have been convicted regarding that particular type crime. So take a look at this one. It's a super interesting case, albeit depressing. It is a good case to watch. So let's talk about or give you a short history, if you will, of the victim. Now, throughout much of early human history, victims had few, if any, real official support mechanisms. Nonetheless, early social norms generally supported the actions of victims who, before the emergence of organized law enforcement and formal court systems, were able to extract or exact revenge on those who had victimized them. Now, such early victims typically sought the support of friends and family members in hunting down and punishing the suspects. And moreover, early tribal codes generally required families to care for the needs of victims or their survivors. Now, this early period in history, during which victims took an active role in determining the fate of offenders, and during which the care of the victims was socially mandated, was termed what we called the Golden Age of Victims. So again, this is a historical period during which victims had some well-recognized rights, including a personal say in imposing punishments on apprehended offenders. And later on in Western legal tradition, victims were expected to provide evidence of a crime and to testify against those who had offended them. But let me kind of go on a little bit. So the Golden Age lent a sense of closure to the victimization experience and had the effect of making victims feel whole again. And eventually, however, crimes came to be seen as offenses against society, and the needs of the victim were largely forgotten. By the late Middle Ages in England, the concept of the King's Peace had emerged, under which all offenses were seen as violations of laws decreed by the monarch. And under the King's Peace, it became duty of local officials, including sheriffs and constables, etc., to apprehend offenders and to arrange for their trial and punishment. And as a consequence, victims were effectively removed from any direct involvement in deciding the offender's fate. Now, again, from that point onward in Western legal tradition, victims were expected to not only provide evidence of a crime and to testify against those who had offended them. And society's moral responsibility toward making victims whole again was pretty much largely forgotten, and victims as a class were moved to the periphery, or the outside, if you will, of the justice process. So the golden age of victims, again, this was a historical time during which victims had well-recognized rights, including a personal say in imposing punishments on offenders, etc. So victim-centered justice had been transformed into state-centered justice, under which the victim played a mere token role as the personal target of criminal activity. Now, not much really changed until the 1960s, and California actually passed the first American legislation intended to assist victims of crime in 1965. So from there, many states then joined the victims' compensation bandwagon, and today all 50 states and the District of Columbia have passed legislation providing monetary payments to crime victims. So this is kind of an interesting concept, okay, where compensation has been allowed. So if I could back up just a little bit, the first modern victims compensation statute was adopted in New Zealand back in 1963, and that was known as the Criminal Injuries Compensation Act. And it provided a mechanism for claims to be filed by victims of certain specified crimes. And under the law, a 3-member government board was created with the authority to make awards to victims. And a year later, partially in response to a movement led by victims' rights advocate Margaret Fry, Great Britain passed a similar law. And then that's when we come into the part about in 1965, California passed the first American legislation intended to assist victims of crime. And about the same time, the New York City Council passed a Good Samaritan statute designed to pay up to $4,000 to anyone suffering physical injury while going to the aid of a crime victim. Now again, as I previously stated, many states then joined the victims' compensation bandwagon, and today all 50 states and the District of Columbia have passed legislation providing monetary payments to crime victims, although legislatures have rarely funded programs at levels that would pretty much pay all requests. Now, modern state victims' compensation programs require applicants to meet certain eligibility requirements. So they're not just going to pay you for nothing. You have to meet some requirements. And most set award maximums. And victims, however, who are responsible in some significant way for their own victimization are generally not eligible for reimbursement under these particular laws. So, you know, you have to kind of understand there are some elements to this that have to be met. Now, in California, for example, qualifying victims of crime may receive financial assistance for losses resulting from a crime when those cannot be reimbursed by other sources. The State Board of Control's Victims of Crime Program administrators or administers California's Crime Victim Compensation Fund. And under this law, victims of crime and their survivors may be eligible for financial reimbursement under 5 different categories: medical and hospital expenses, lost wages and support, funeral and burial expenses, professional counseling, and job retraining and rehabilitation. Now, California law requires that applications from adult victims be filed within 1 year of the date of the crime, whereas applications resulting from a crime against a minor must be filed before the minor's 19th birthday. So again, there's a lot of different aspects to this. So with that being said, let's look a little bit about the philosophy of victim compensation. So victims' compensation programs find their philosophical underpinnings, if you will, in several different schools of thought. One is strict liability theory, which claims that compensation is due to victims because the social contract between victim and society, specifically government, which has a duty to safeguard its citizens, has been broken by the experience of victimization. So that's one thought or philosophy on compensation. Now, another one is the government negligence theory. And this holds that the government was negligent for allowing harm and should make appropriate forms of compensation. So that's number 2. Another philosophy is the equal protection theory. And this says that compensation should serve to level out imbalances, if you will, in society, including the huge variation in crime risk faced by those living in different parts of the nation and under different social conditions. The next one is the humanitarian theory that advocates compensation because of the suffering that victims undergo. Another one, or another 2 here we have on this slide, would be the social welfare theory, and this says that victims should be compensated if they are in need. And then you have the crime prevention theory that holds that compensation programs encourage more citizens to report crime, thereby resulting in more productive or effective law enforcement programs. And then finally, you have the political motives theory that says that victims' compensation is in vogue with the voting public, and that any politician who seeks public office must inevitably support the concept. Now, an interesting thought just to bring up, it's a little off track, but I want to bring it back up, and I want to bring it up under the crime prevention theory. So now, again, this theory holds that compensation programs encourage more citizens to report crime, thereby resulting in more programs, more effective law enforcement programs. Well, how about this? There's a new trend that's coming around in the U.S., and it's in a couple of cities in California already. Richmond, California is one of them, where now there are guidelines and specifications to this, but they are typically, in essence, paying criminal offenders not to offend. Now, there's a lot more to this, so I just wanted to kind of throw that out there. But how would you feel about giving an offender who meets certain criteria, of course, compensating them $1,000 a month for 9 not to continue their criminal activities? And that's a very thin summary. There's, again, a lot more to it, but think about that as we kind of talk about some of these strategies and victimization as a whole. So, and then there's the post-crime victimization. Now, this particular one talks about problems of the victim that follow from an initial victimization, such as loss of employment or inability to pay medical bills and insensitivity of family members. And it's also called, or what we call, secondary victimization. And we know this because, victims experience many hardships extending beyond their original victimization, right? Including the trauma of testifying, the uncertainty about their role in this whole justice process thing, lost time at work, trial delays, fear of retaliation, and a general lack of knowledge about what is expected of them as these things we call wheels of justice kind of move forward. So problems that follow from the initial victimization, again, these are referred to as post-crime victimization. And it is something that we do have to understand. And as we talk about that, they have this interesting theory called the leaky net theory. And this deals a little bit with a term called restitution that we'll get to. But many victims assistance programs, they're designed to provide comfort and help to victims of crime. They've developed recently. We've got a lot of them, but if you look at this leaky net when it comes to victim assistance programs, you can look up here, and the chart basically looks at the amount of crimes committed. And then it looks at crimes not reported, by the authorities. And then it starts to go down to the bottom. Crimes not responded to or investigated, people not arrested, people not charged, people not prosecuted, people not convicted, all the way down to criminals not willing to make restitution. And at the very bottom, after all this stuff is kind of weeded out, you have a very small portion of those criminals who actually repay their victims. And this is the essence of this thing called the leaky net theory. So, and pretty soon, in a few minutes, we're going to talk about restitution. So keep that in mind as we start to kind of move forward through some of these different programs. Now, again, in recent years, there have been numerous victim assistance programs designed to provide comfort and help to victims of crime, and they have developed across the nation. The earliest of these programs began as a grassroots movement designed to counsel victims of rape. In 1975, a national survey identified only 23 victims assistance programs across the United States, but by 1986, the number had grown to more than 600. And estimates today place the number of such programs at more than 1,000. So what is a victim assistance program? Well, it's a service organization that works to provide comfort and assistance to victims of crime and to witnesses. So let's look at a couple of different ones that are out there. So two large nonprofit public groups that serve the needs of victims on a national scale are the National Organization for Victim Assistance, and again, we've got acronyms, NOVA, and the National Center for Victims' Crime. And they are both in Washington, D.C., and they provide leadership in victim education, they lobby in Congress, and they hold conferences and workshops designed to assist local victim witness assistance programs. A couple of more, the Victim and Witness Protection Act of 1982 was enacted to enhance and protect the necessary role of crime victims and witnesses in the criminal justice process. The Federal Office for Victims of Crime also plays a pivotal role in the victims movement. The Violent Crime Control and Law Enforcement Act of 1994 contained significant legislation on victims' rights. The Federal Crime Victims' Rights Act of 2004 has been described as the most far-reaching victims' rights bill ever considered by the U.S. Congress. Now, when we talk about the growth of victims' rights, when the victim movement began, the idea of legal rights for victims of crime was novel. And at the time, victims advocates built a platform of victims' rights on 6 basic principles. So they talked about victims and witnesses have the right to protection from intimidation and harm. Victims and witnesses have the right to be informed concerning the criminal justice process. Victims and witnesses have the right to reparations. Victims and witnesses have the right to preservation of property and employment. Victims and witnesses have the right to due process in criminal court proceedings. And victims and witnesses have the right to be treated with dignity and compassion. Now, more than 30 states and the federal government have enacted legislation or have modified their constitution in recognition of victim rights. And a key focus of victim rights advocates today is the passage of a federal constitutional amendment. And that brings us to a very interesting law out there, and it's called the Son of Sam laws. Now, first, not everyone thinks a victims' rights amendment to the Constitution is a good idea. Now, Elizabeth Semel, a San Diego attorney and a member of the National Association of Criminal Defense Lawyers, said of an earlier version of a resolution relating to a constitution, said, "We have a constitutional system that is intended to be out of balance. That's what the presumption of innocence is all about. The proposed amendment would have an impact at a stage when someone merely is accused of a crime, not convicted of one." So a very interesting thought. I'm not saying it's right or wrong, but it certainly is something to think about. Would having some type of amendment to the Constitution change that thought process of you're innocent until proven guilty, which is kind of in a nutshell what this individual, Elizabeth Semel, is trying to tell us right here. So now let's look at something called the Son of Sam law, a very interesting one. So notoriety for profit statutes, also referred to as Son of Sam laws, provide additional support for the rights of victims. And notoriety for profit laws are intended to deny convicted offenders the opportunity to further capitalize on their crimes. And it kind of makes sense. The law works by setting the stage for civil action against infamous offenders who might otherwise profit from the sale of their story. And a few state laws also target the sale of memorabilia, which that's kind of disgusting, but okay, associated with the crimes. Now, most such laws hold potential for profits in an escrow account, allowing victims of their survivors the time necessary to file suit. But think about it. Think about some really big case where somebody, some criminal, let's use the Night Stalker, Richard Ramirez, who committed several burglaries, sexual assaults, rapes, and murders, and torture. Probably about 30, I can't remember exactly how many people, but I'm going to go between, let's say, 25 victims. How would you feel if he sold that story and was able to profit from his particular crimes? And take it a step further, what if he was able to sell Richard Ramirez bobbleheads? And I know that's disgusting, but I'm trying to get the point across that this is part of this statute that basically deals with victims' rights, knowing that this person cannot capitalize on their crimes. So for me, it kind of makes sense, and I don't know if it makes sense for you, but there you have it anyway. Now, these Son of Sam laws exist today in 43 states and at the federal level. So now just kind of a little note here. After his capture, there were reports that book and other print publishers were frantically trying to buy the rights to Berkowitz's story. Now, this is actually the individual that was involved in the Son of Sam killings. Now, to prevent him from making a fortune off his crimes, the New York legislature passed this law, thus the Son of Sam law, after this case. And then many states followed New York's lead and passed similar laws. And I have a little video that you can watch at your leisure on the Son of Sam, but this was an actual case, and thus the law was kind of named accordingly. So that gives you a little bit of information on the Son of Sam case. Now, again, they apply to any convicted felon and provide that when an offender enters into a contract to receive profits from the recounting of the crime, as in a book, movie, TV show, etc., all profits which would otherwise be paid to that offender must instead be paid to the benefit or held for the benefit of the offender's victims, which kind of makes sense. So sure, take your money or get your money, but you're not going to get it. You can tell your story if you want, but any proceeds from that are going to go to that offender's victims. And yeah, that's I guess a better idea. So now that brings us to what we call victim impact statements. So another result of the victims' rights movement has been an ongoing call for the use of what we call victim impact statements before the sentencing of convicted offenders. So they've been convicted. This is just at the sentencing part. Now, victim impact statements are generally, or they generally, take the form of written documents that describe the losses, suffering, and trauma experienced by crime victims or by surviving family members. Now, jurisdictions that have laws supporting the use of victim impact statements expect judges to consider them in arriving at an appropriate sanction for the offender. So that makes sense. So let's go over it again so we have a good handle. The in-court use of victim or survivor supplied information by sentencing authorities who want to make an informed sentencing decision. That's a victim impact statement. It can also be a written document that describes the loss, suffering, and trauma experienced by the crime victim or by the crime victim survivors, or, and more frequently what you see would be an impact statement orally, where somebody gets up and makes a statement in court before the sentencing. So orally, the principle here that oral testimony and cross-examination, particularly at trial, is more valuable than written testimony. And under the Confrontation Clause, this found in the Sixth Amendment, it guarantees criminal defendants the right to confront and cross-examine both witnesses and accusers at trial. So this is the confrontation part. So again, one of the central features of the adversarial system in our court system is what they call orality. And orality is the principle that oral communication is valued more highly than written testimony, and that fairness demands the opportunity for the accused to confront and cross-examine both accusers and witnesses. And the principle, again, of orality can be found in the Sixth Amendment's Confrontation Clause, which provides that a criminal defendant has the right to be confronted with witnesses against him. Now, when we go back, just really quick, I want to go back here. When we talk about victim impact statements, I want to address just quickly the constitutionality of these statements. Now, victim impact statements met a significant constitutional challenge in 1987 in the case of Booth versus Maryland. And this case involved Irving Braunstein, 78, and his wife Rose, 75, who were robbed and brutally murdered in their home in Baltimore, Maryland in 1983. Now, arrested were John Booth and Willie Reed, acquaintances of the Braunsteins, who were caught stealing to support their heroin habits. And Booth and Reed were both convicted of murdering the Braunsteins. Booth, however, decided to allow the jury rather than the judge to set his sentence. And as required by state law, the jury considered a victim impact statement that was part of a pretense report prepared by the probation officer. And the victim impact statement used in the case was a powerful one, describing the wholesome personal qualities of the Braunsteins and the emotional suffering of their children, and how the children and how it was experienced by them as a result of the murders. Now, Booth received a death sentence, but appealed, and his case eventually reached the U.S. Supreme Court. Now, the court overturned his sentencing, reasoning that the victim impact statements, at least in capital cases, violates the Eighth Amendment ban on cruel and unusual punishment. In a close 5-4 decision, the majority held that information in the victim impact statement leads to the risk that the death penalty might be imposed in an arbitrary and capricious manner. Now, as you have learned in the opening of this lecture, the U.S. Supreme Court recanted the Booth ruling, meaning they changed it, explaining that it had been based on a misreading of precedent. So, although generally acceptable after the Payne decision, there are due process limits to the admission of victim impact evidence. So hopefully that kind of clears that up a little bit. So now, and then we talked a little bit about confrontation and how that plays into this. Well, kind of finishing up with this, there are exceptions to the rule of confrontation. And the Supreme Court has held that out-of-court statements that were made for the purpose of proving the fact in question, meaning guilt of the defendant, and where the defendant had the opportunity of cross-examination, may be admitted at trial, even in the absence of the witness for cross-examination at trial. And lower courts have also recognized the dying declaration exception, which applies to statements made while a person is facing impending and immediate death about the cause of a person's death. And I have an example that you can look at regarding a very interesting dying declaration thing. So what about statistics? How many have we tried to put numbers to some of this? Well, it's difficult to know precisely how much crime is committed yearly in the United States. On one hand, Many crimes go unreported, and on the other hand, victims may describe their victimization experiences in terms that do not really fit some of these statistical categories used for determining official counts of crime, if you will. And in addition, numerous false reports are filed, and real victims sometimes they hesitate to report their victimization. Now, two major surveys provide annual crime statistics for the United States in an effort to measure the extent of criminal victimization throughout the nation. Now, one is the Uniform Crime Reporting Program, or UCR, which now incorporates the National Incident-Based Reporting System. So again, there you have UCR and then NIBRS. You have all these acronyms, and collects data from police departments across the country about the number of crimes reported or known to the police. Now, the National Crime Victimization Survey is based on victim self-reports that are made to survey interviewers and obtains information about crimes that are not always known to police. And this is one typically uncovers more criminal activity than the UCR. So the UCR basically is based on what police know and what they report. Well, the victimization survey actually is based on victim self-reports that are made to survey interviewers, and it obtains information about crimes that may not be known to the police. So we have a couple of different statistical avenues, if you will. So the National Crime Victimization Survey, again, is based on victim self-reports that are made to survey interviewers, and again obtains information about crimes that are not always known to police. And some problems occur with the accuracy, since this report samples U.S. households and largely omits the homeless and others not attached to traditional households. So you can see how maybe we're not getting all of that particular data. Now, again, the NCVS is the government's primary source of information about criminal victimization. And twice a year, data is obtained from a nationally representative sample. And the Bureau of Justice Statistics annually polls people over the age of 12 about crimes like rape or robbery, assault, larceny, burglary, and motor vehicle theft. And again, there is some difficulty in obtaining certain kinds of information through a survey, because the NCVS does not collect data on certain categories like child abuse or drug abuse, and undercounts others such as rape and domestic violence. So again, it's not all perfect, but these are ways to try to get some statistical analysis. Now, if you look at page 451 in your textbook, there's a table down at the bottom that has a comparison of the UCR report and the NCVS report. And it's got it in two different columns, so it's basically a comparison of the two reports. So an example for purpose. For the UCR, it's data collected for law enforcement agencies as well as public researchers. And the NCVS, it's collect data not provided by the UCR, including commonly unreported crime and victim and offender data to be used by agencies and public researchers. So you can see there is a pretty interesting comparison between the two. And again, when you talk about victim statistics, it does show that about 63% of all crimes are never brought to the attention of police. And the example I can give you is what we call the dark figure of crime. And I don't mean that in the sense that it's like the ooh about crime, it's criminal and etc. What it really means is that we typically know what's on top of the water because we can see it. because that's what people report. Well, what about the other stuff underneath? All those crimes that aren't reported. And that's kind of what they're trying to solve here in the victimization survey and some of the other surveys that are out there and statistical accounting reports. Now, when we talk about violence against women, one result of heightened interest in women's victimization was the creation of the Federal Violence Against Women Office, and another was the initiation of a National Violence Against Women survey. And this NVAW, another acronym, survey also gathers information on men's victimization as well. So this statistical analysis is a good thing. We're trying to get as much information as we can. And the survey basically found that nearly 1 in 6 U.S. women have experienced an attempted or completed rape at some point in her life. And you probably didn't know that. And the NVAW survey also found that women experience significantly more partner violence than men do. 25% of surveyed women, compared with 8% of surveyed men, said they were raped and or physically assaulted by a current or former spouse, cohabiting partner, or date in their lifetime. And the NVAW survey shows that violence against women is a primary partner violence. Well, what about that thing again, the Uniform Crime Reporting? Because we don't want to leave that out. We want to make sure that we talk about, crime data in general, because it is important. Well, the FBI's Uniform Crime Reporting Program collects data about offenses known to law enforcement in 2 major categories: violent crime and property crime. Now, it also collects information regarding clearances of these offenses, meaning crimes that have been solved. And under the UCR program, violent crime consists of 4 offenses: murder and non-negligent manslaughter, forcible rape, robbery, and aggravated assault. And violent crimes are defined by the UCR program as those offenses that involve force or threat of force. And the UCR program uses a hierarchy rule, if you will, that requires that only the most serious offenses in a multiple offense criminal incident be counted. Now, I put a link in here that you can go to if you want to know. And the UCR collects data on states or even cities. So this is the Uniform Crime Reporting website. It's the UCR. It's ran by the Federal Bureau of Investigation, the FBI. And here's all the different types of publications. And we even have some latest releases. There are statistics on officers killed. There are statistics on hate crimes. But if you look all the way down here, you can see all the different types of things that you can get. And then here is kind of a summary of what happened. But if we go here, they have publications, and one of them is Crime in the United States. And it will list by all the different years. So this is a good place for you to go if you want to know what type of crime is happening, let's say in your community or even in your state. Now, according to UCR statistics, an estimated 1,163,146 violent crimes occurred throughout the nation in 2013, or 368 violent crimes per 100,000 inhabitants, a 6% decrease from the year before and 14% below 2004. And this lends into the whole crime debate on whether now is crime up or down. And statistically speaking, property crime in this last year, in 2017, throughout the report, property crime is up, violent crime is down in some states, and it's up in some states. But you can look at that UCR and it'll give you a little bit more information. Now, a couple of crimes that it tracks, and then we'll be done with the lecture for today. The UCR program again defines murder, or it collects what we call Part 1 crimes. And some of them are crimes against person and some are property. I'm going to walk you through those and then we'll be done for this particular lecture. So the UCR program defines murder and non-negligent manslaughter as the willful killing of one human being by another. And it doesn't include things like deaths caused by negligence, suicide, or accident, justifiable homicide, and attempts to murder or assaults to murder, which are basically scored as what we call aggravated assaults. Forcible rape is defined by the UCR program as the carnal knowledge of a female forcibly and against her will. Now, UCR data category also includes assaults and attempts to commit rape by force or threat of force, but statutory rape without force and other sex offenses are excluded. It defines robbery as the taking or attempting to take of anything of value from the care, custody, or control of a person by force or threat of force or violence, and or by putting the victim in fear. Now remember, different states have different elements to their crimes. These are just kind of overalls. Defines aggravated assault as an unlawful attack by one person upon another for the purpose of inflicting severe or aggravated bodily injury. Burglary, so now we're going to switch to property crimes, as the unlawful entry of a structure to commit a felony or theft. Larceny or theft as the unlawful taking, carrying away, leading, or riding away of property from the possession or constructive possession of another. Motor vehicle theft as the theft or attempted theft of a motor vehicle. And arson as willful or malicious burning or attempting to burn with or without intent to defraud of a dwelling house, a public building, a motor vehicle or aircraft, the personal property of another, and so on. And that brings us to the final couple of things to talk about would be restitution. So this is typically a court-appointed requirement that a convicted offender pay money or provide some type of service to the victim of the crime or provide services to the community. And that could be like picking up trash or painting a wall or paying for the damage when they broke a window or etc. And that's kind of the essence of restitution. Now, restitution differs in nature from government-sponsored victim assistance. Okay, court-ordered offender restitution is a sentencing option that forces the offender to assume at least some financial responsibility for what he or she did or the crime that they committed. And then finally, restorative justice. A kind of a new program. It has been around for a little bit, and it's gaining some steam in the United States, and typically in some European countries it's been enacted for a while. But restorative justice builds on restitution and other sentencing strategies to benefit all parties affected by the criminal event, that is the victim, society, and the offender. And there's an option of restitution in there that can be included. So you have restitution, community service, victim offender mediation, victim empathy programs, driver improvement programs, all of these things. And basically, it's an option that instead of the person, let's say, doing jail time, if they meet a certain criteria and they're willing to be involved in this program, they can not only get restitution, but they may do some things like community service or even offender mediation, where the suspect meets with the victim and they talk about what happened. And that way the victim can basically get some closure on maybe why the person burglarized their house. And the offender has to admit that they did it. So there are some different thoughts on this particular thing called restorative justice. I have a link to a really good video. It's only about 9 minutes long that covers restorative justice, and I would really suggest that you watch it because it is kind of a new thing over here, and not everybody thinks it's something that we should be doing. But in some places, it has been beneficial. So with that being said, we made it pretty much underneath our time limit, but just barely. Don't forget, as a reminder, to look at the summary portion at the end of the chapter that hits the highlights. And also, Don't forget to look at the key terms either in your at the end of the chapter in your textbook or on Canvas, where I put them in there for you to look at. So with that being said, that will conclude our lecture on chapter 13, and until next